So welcome to this event, which is being organised by ACH. For those who don't know, I think most do, we're a social enterprise who provide integration and resettlement support to refugee and migrant communities. We particularly work in the west of England and the West Midlands, but we do work in other parts of the country. The reason to do this event really is that back earlier in the year, the Borders and Nationality Bill was, when it was a bill, was the subject of obviously a lot of controversy, a lot of conflicts and a lot of criticism, quite rightly. But now that bill has been law for a while, and I think it's quite important for us just to take a step back and see to what extent it's going to have an effect on organisations who are working in the field, and more importantly, on those people who are in the asylum and refugee system, in terms of the practicalities that it will impact on them in terms of integration, resettlement, in terms of housing, in terms of well-being, in terms of employment. So that's the purpose of the event. Basically, the structure will be, we've got three speakers. Firstly, Colin Yeo, who is a leading barrister in the field of refugee and migrant law, and heard Colin speak a few times now, and I have to say he is able to present quite complex things in a very accessible and understandable way, and I think is an ideal person to give us an introduction to this context. A few years ago, before I worked with ACH, I was not at all familiar with the whole refugee and asylum landscape in terms of detail, and sometimes it is bafflingly stupid. But I now realise that's because it is bafflingly stupid, not because I didn't understand it properly. And then we've got Beth Wilson, who is the for another week CEO of Bristol Refugee Rights. Beth has been a leading person in the field of asylum seeker support, refugee help assistance, and working with our migrant communities in Bristol for the last few years, and has managed to really mainstream Bristol refugee rights in terms of its role in the city and the wider area. And she can be speaking more about the practicalities of the impact on asylum seekers and other client groups that they work with. And then Emma Gaspar, who is our ACH team leader for our support team, who has the day-to-day responsibility of working particularly with the tenants in our properties who come from asylum route refugee backgrounds. Their generic needs she's very familiar with, so she's got a lot of hands-on knowledge of the actual experience of refugees as they start to resettle through the current process, which is bad enough, but let's consider how it will be in the future. And she's also working with other groups like Ukrainians in South Gloucestershire and others too. And then we'll then have a period for discussion. And lastly, my colleague Rosie McLennan, who is the head of our comms team, will do a policy wrap-up, because it's always important to me that we actually identify some actions we can actually do, as opposed to just talk about it and feel good that we've had the conversation. So I'd like at the end, we can agree 2 or 3 things we can actually do to change things. So that's the structure of the event. Please feel free to post in the chat who you are and your interest. That'd be really interesting too. You can see from the list of participants the names of people, but we don't always know exactly who they are and what they're interested in. So if you want to put stuff in the chat, please do that. Equally, for the discussion session, please either put the question in the chat and myself and my colleagues will monitor that, or put up your virtual hand to indicate you want to say something. I also need to say that we will be recording this, so if you don't want that to happen, then turn off your camera and be aware that we will be doing that. Please keep your microphones off when the main session is happening, just so we don't get interference of, dogs barking or bookshelves falling over or any other problems. So please do that too. And I think that's more or less my housekeeping points. So yeah, so I think we can now start off and ask Colin to make the first presentation. Presentation will be reasonably short, 15-20 minutes each, and then we'll have the discussion.
Right, thank you very much, David. I feel like I possibly should have asked you to give a trigger warning before my first slide came up there with the former Home Secretary Priti Patel's face and her landmark Nationality and Borders Act 2022. It's in some ways a typical piece of immigration asylum legislation, because it doesn't, this isn't what you'll have heard while people were campaigning during the passage of the act. But my own view as a lawyer is that it doesn't actually do a lot. And it's not that things don't need to change in the asylum system. But really, this piece of legislation doesn't really seem to actually have any of the impacts that anybody, wherever they might lie on the refugee rights kind of spectrum, might wish for. So if I just move on to the next slide, there are some serious problems. I'll give you a kind of foretaste of what I'm planning to say today. There are serious problems with the asylum system. The small boat crossings are, to my mind, a very serious problem. It's not that there weren't people coming before by dangerous routes. Getting into the back of a lorry was not safe. We saw some awful tragedies with that, a lot of injuries short of death with people trying to get into the back of lorries and so on. But small boat crossings are deeply problematic. There's also the asylum backlog. It's a very serious problem with the asylum system at the moment. And more on the kind of turf of ACH, there are increasing obstacles to integration for refugees, many of which are made worse either deliberately or accidentally by government policy, and the Nationality and Borders Act either, to put it kindly, does nothing to address those, but actually, as we'll see, it may actually make some of those problems worse, and it certainly adds a degree of additional misery to the lives of at least some refugees. So before I sort of talk about the legislation, I just want to contextualize this a bit and go through 4 slides to show you what I think are some of the key features of the contemporary asylum system. So first one, if we just go back a slide to asylum applications per year, you can see that this is by year, first of all. So if you look at 2021, the last slice of data that's captured here was at the end of last year. So this chart is effectively almost a year out of date. And in fact, the numbers per quarter have gone up since then. And this chart doesn't capture that. But what it does show is that we're still some way off, even if you add this year's figures to it, we're still some way off the peak in 2002 or so of over 80,000. And this is asylum applications per year. So the number of actual people is higher than this because there are dependents included on these applications. You can also see small boat arrivals there. And the point that a lot of us were making in the kind of advocacy space in the sector around small boat arrivals to begin with was that this represented a change of route. And you can see that in 2020, the actual number of applications fell at the same time that the number of small boat arrivals increased. But that's no longer true, and it's become even less true over subsequent quarters in 2022. So the small boat arrivals are driving now an overall increase in asylum numbers. But if we can move on to the next chart, we can see that it's not quite how the government would present it. So the government would like to say, look, it's this flood of refugees. They use all sorts of unpleasant words to describe this, that is causing the asylum backlog and creating all these problems in the asylum system. And we can see that to some degree, the number of arrivals has increased, but the real problem is that the number of decisions hasn't kept pace and in fact has declined. And the result of that is a massive increase in the asylum backlog. So there are now over 140,000 people waiting for asylum decisions. And the Home Office doesn't release data on the average waiting time for a decision, but we understand it to be years, essentially. It's quite hard to tell because the Home Office is thought to be applying some degree of streaming, although they're very, very unclear and untransparent about how that works. So some people seem to have their claims accelerated, perhaps if they're more vulnerable, perhaps if they're from certain countries, but we're not really all that sure about that. And it doesn't seem to be applied consistently. So, it looks like people are waiting basically probably 2, 3, 4 years for an asylum claim. So the people who are arriving in small boats this year, they're not actually going to get decisions on their claims if things don't change for several years. Right, now the next major feature of the asylum system is in the next chart, which is a substantial increase in the grant rate. Can we just move on to the next slide there? So if we go back to, it's not on this chart starts in 2010, but if we go back to the mid-90s, about 4% of people claiming asylum were getting recognition as a refugee. It was a very small number. it hovered, and this actually includes all grants of asylum, so not just refugee status, but also discretionary leave to remain, humanitarian protection, so on. And it was hovering around the kind of 25, 30%, bit higher than that for many years. And then it shot up basically in 2019, and then shot up further in 2021. And it's actually gone up since then. So it's now standing about 76% overall for all people who are receiving asylum decisions. Of course, we're talking about people who arrived a couple of years ago at this point in time because of the delays in the system. And the current Home Office stats suggest that there are 3 countries where literally 98% of people who apply for asylum are getting positive decisions from the Home Office before an appeal is taken into account. And I think off the top of my head, that's Syria, Afghanistan, and Eritrea. Iranians have a very high percentage chance, but that's there's been all sorts of extra problems in Iran since the latest quarterly statistics were sort of looked at and so on. So some countries are really getting a very, very high success rate, and that seems to be what's driving the overall increase to some extent in the success rate. Now, the final thing, but just before I move on, actually, and the reason I'm showing this one in particular is that it's worth remembering that what this means is that most of the people who are arriving in the UK as asylum seekers are going to get asylum. They're going to be here for the long term. And that's reiterated by this next chart on returns of former asylum seekers. And I think a lot of people aren't necessarily aware of this, but you can see that this breaks down into enforced and voluntary returns. And enforced returns already in 2010 were way below their peak of about 2004, 2005, when a massive 20,000 failed asylum seekers were removed. It had already fallen by 2010, and it's fallen since then as well. And according to the Home Office stats, an almost unbelievable 113 failed asylum seekers were removed in the whole of 2021. Now, that's not many people. And the point that I want to make here is that it's not just the people who are granted asylum who are staying in the UK long term. It's anybody who claims asylum is staying in the UK long term. The chances of removal, the percentage chances of removal are really rather low, given that enforced removals are so low, and so are voluntary returns as well. But we're just simply not seeing government policy recalibrating or being rethought in order to reflect this in any meaningful way. And in fact, quite the opposite. So let's have a look at some of the things to do with the actual legislation itself. And I'm going to start with Rwanda, if we can move to the next slide, because that's kind of the headline policy for the legislation. The government itself said that they needed the Nationality and Borders Act to come into force in the spring in order to deal with small boat arrivals this year. The reality, though, is that the Home Office didn't actually wait for the legislation to come into force before they started with the Rwanda removals, or attempted removals, because nobody's actually been removed yet. They instead relied on a law from 2004. And it turns out that this legislation was not necessary, basically, for the Home Office to carry out what they're calling the Rwanda plan. So even if it succeeds, if we look at this with it's try and be objective about this, aside from the kind of performative cruelty of it, even if some people are eventually removed to Rwanda, it's going to make very little difference to the system as a whole, because the Rwandans are saying they can only accept a maximum of about 300 a year. The UK has been trying pretty hard to find other countries with whom they can announce a sort of similar arrangement, and haven't yet found anyone. It may be that lots of those deals suddenly follow. It may be that the Home Office has actually inked arrangements with lots of other countries, just hasn't announced it yet. But what we're seeing is that a lot of people say, well, people shouldn't claim asylum if they've traveled through a safe country. But the reality is that there's only one country that people can be sent back to, and that is their own, unless there is a third country that will accept them back. And that's what we mean by third country. It's kind of not your own country, not this country, it's a third country. And since the UK left the Dublin system, there have been no third country deals in position. So it doesn't matter whether you claim asylum from traveling through a safe country. There's no, you can't get those countries to accept you back. They're not forced to accept you under international law, and there's no deal with them in order to facilitate their return there. So unless something radical changes with the Rwanda plan and it expands to other countries and so on, it doesn't seem like it's likely to make much of a practical difference on the ground. So let's move on to another slide and another one of the sort of big headline policies that was announced through the legislation. Now, with my sort of lawyer's metaphorical hat on rather than literal hat, I can say that this whole differential treatment idea, which is the idea that depending on how you arrive in the UK, you'll be treated differently as a refugee. So if you arrive by the safe and legal routes, and there are substantial safe and legal routes, but they're limited only to certain countries, effectively 2 countries, Hong Kong and Ukraine. There's also a scheme for Afghanistan. There's also theoretically a scheme for others around the world, but they're just failing to operate. They're just not working, basically. If you arrive through those routes, you'll be treated in one way. If you arrive by irregular routes, as they say, in a small boat or in the back of a lorry or something like that, then you'll be treated in a different way. Now, they didn't need an act of parliament to do this. You don't need primary legislation. All you have to do is change the immigration rules. But that's a kind of lawyer's argument. The fact is they have put this into primary legislation, whether they needed to or not, and they have indeed implemented a 10-year route now to refugee settlement. So I've been doing this for 22 years now. I can remember when refugees were given settlement immediately after 1 year of leave. So they're granted one year of leave and then settlement. I can remember when they were granted settlement immediately on receiving refugee status, and then it was 5 years for a long time, and it's now 10 years. Now, that creates emotional insecurity. It makes people feel insecure. But look at the number of removals that we saw earlier in that chart. The reality is that it is really hard to remove failed asylum seekers. It's even harder to remove people who've had lawful stay and had jobs in the UK and put down roots in the community. And the reality is that almost nobody gets removed after 5 years before when they're applying for settlement. And it's very unlikely that anybody's going to be removed during that 10-year period, because the Home Office can't even deal with people who were refused asylum in the first place. So the idea that they'll then be actively removing people sort of further down the process who were actually recognised as refugees seems a bit outlandish when it comes down to it. Now, if we move on to the next slide, one of the policies involved in this is potentially to subject people on this 10-year route to a no recourse to public funds condition. So they wouldn't have access to social benefits, essentially. The government announced that it was going to do this and then said that they were pausing implementation. And I think the reason, I could be wrong about this, I think the reason for that is that they realised that that would actually seriously, blatantly breach the obligations of the Refugee Convention. So, lawyers like me tend to focus on Article 1A2 of the Convention, which is the definition of refugee. There are loads of other articles to the Refugee Convention which give recognised refugees their rights, and this includes Article 23 on public relief, and also Articles 21 on housing, Article 24 on labour legislation and social security. And refugees are entitled to these things if they are refugees. The Refugee Convention doesn't say anything about different types of refugee or anything like that. So it's very hard to see how the Home Office could implement that policy without blatantly breaching international law. And the government's not keen on international law. It doesn't like international law. It tries to find wiggle room to get around it and so on, where there's ambiguity. I can't see any ambiguity here. It's just their policy would clearly breach this. They could do it anyway. They could be in breach of international law. There's no International Court of Refugees to enforce it or anything like that. But generally speaking, the UK government doesn't like to blatantly breach international law. And it would be pretty pointless anyway, because it's hard to see how that would act as a genuine deterrent. I'm going to move on to a couple of other things to go through relatively quickly, because these are real life impacts. I think they will affect some people, but a relatively small number of them. So one is the change to the criminal offences around entry to the UK. And previously, and then cases have established this over the years, it basically wasn't a criminal offence to claim asylum in the UK. There are things you could do that might breach the law, like coming through the Channel Tunnel as kind of a kind of different type of offence and so on. But basically speaking, that you weren't committing an offence by coming in the UK to claim asylum. But you are now, and the legislation makes it very clear that a person who arrives without entry clearance, who needs it, and they know it, is committing an offence. So basically, all refugees are now committing an offence when they arrive in the UK. The thing is that they're protected by the Refugee Convention from being penalised or sanctioned for doing that. And we're also talking about maybe I think it's 71,000 is the in the year ended September. We're talking about 70-odd thousand people all being prosecuted and convicted. We just don't have the prison space for that. It's impractical to prosecute and convict them. And if we move on to the next slide, we can see that actually the government's plan has never been to prosecute everybody. It's instead to pursue a selective prosecution policy, or another word for selective would be discriminatory, basically. So you pick on some people that you don't like, perhaps because of their route of entry, and perhaps the danger is that maybe other factors that are taken into account, either consciously or subconsciously. So not everybody is going to be prosecuted. I have heard there have been about 400 prosecutions over the last few months, so it's a significant increase in the number of people compared to previously, but we haven't seen what's going to happen in terms of whether they've got defences that they can rely on under kind of common law and relying on the Refugee Convention, international obligations and stuff. So this is a kind of developing area of law. We're talking about the low hundreds of people compared to 70,000 people entering the UK, but this certainly does make your life a lot more miserable if you are an asylum seeker. Okay, moving on to next slide. There are some provisions on reinterpreting the Refugee Convention. Frankly, pretty weird. None of it is likely to have much of an impact in the greater scheme of things. The standard of proof is slightly toughened. It's hard to see that's really going to make a difference in practice. Some of the bits are redefined slightly. Again, it just seems like sort of almost legislating for its own sake, so sort of filler material almost in the legislation. If we move on to the next slide on rights of appeal, again, there is a potentially substantial change here, where basically there's a single appeal straight to the upper tribunal. Instead of going through the first tier, you go straight to the upper tribunal, and then you have no onward appeal to the Court of Appeal. So if that was used extensively, then it would be very damaging potentially for asylum seekers. But with about 76% of them getting asylum from the Home Office in the first place, about half of asylum appeals succeeding, the delays are caused by the Home Office, not by appeals. Appeals aren't stopping anybody from being removed. So I'm not sure that this is really going to answer any of the questions that the Home Office faces at the moment. And I would suggest that the main problem isn't to do with this new legislation. It's to do with the legal aid market essentially collapsing. And no doubt some of you have heard that one of the big legal aid providers has basically withdrawn from doing asylum appeals, which is going to make it very difficult for some people to find a lawyer to actually represent them. Okay, move on to the next one. Again, this is a change that is certainly going to adversely affect some people, but not that many. The Home Office has, because it's apparently not got enough to do already, decided to recruit its own team of social workers in order to start conducting age assessments instead of local authorities, which is pretty crazy, really, when you think that local authorities weren't doing a sort of terrible job previously. It looks very much like a kind of bit of political obsession, really, by the previous Home Secretary, Priti Patel. There will be a new right of appeal against adverse decisions, which is probably a good thing, most of us would say. I think some of the lawyers are concerned because they'll get paid less well, because it won't be a judicial review challenge. It'll be an appeal instead on legal aid rates. But generally speaking, appeal rights are considered better than having to rely on judicial review. So if I just quickly sum up, likely outcomes from all of this, it's hard to see how any of the provisions in the legislation would be likely to affect the numbers of arrivals. It's hard to see what the mechanism would be for any of this really affecting people's desire to come to the UK. None of it is likely to have any impact on the asylum backlog or on delays, because that's an internal matter at the Home Office. It's about resource management and so on within the Home Office. It's not being caused by pesky lawyers or pesky judges or anything like that. It's just really poorly managed departments, essentially. It doesn't make removals any easier. It's not that removals are being prevented by us pesky lawyers or pesky judges or anything like that. Occasionally high-profile ones like Rwanda might be, but that doesn't explain the low and declining removal figures over the last few years. But it does undoubtedly make integration harder. Policies like putting refugees on 10-year route to settlement, criminalising them on entry, even though they're then going to be granted asylum later. These things certainly do make refugee lives harder in the long run. And it's hard to see how that is a beneficial outcome as far as anybody would be concerned. So that's my quick run through. I hope that's helpful. David, you're on mute. Wouldn't be a Zoom call if nobody had to be told.
No, exactly. I'm just showing you what you shouldn't do. It's part of the training exercise. So, Colin, thank you for that. I think it was very clear, very succinct, and kept to time. So that's all perfect. Now pass over to Beth Wilson from Bristol Refugee Rights, who's going to talk in a bit more detail about how she sees this impacting, particularly on asylum seekers.
Thanks, David, and thanks, Colin, for that excellent run through. So just as a bit of background for anybody who doesn't know, Bristol Refugee Rights provides services to asylum seekers, people refused asylum, and new refugees. We offer a range of holistic services to meet the needs and challenges people experience whilst they're seeking safety in this country, such as social spaces to combat isolation, information, advice and guidance to help people navigate the asylum process, ESOL and volunteering to enable people to be more settled, to gain confidence and to prepare for their life once status has been granted. In the last couple of years, as numbers in the asylum process have increased, as you know, Colin's just explained, you know, down to delays in decision making and increasing number of arrivals. The vast majority of people that we have been working with, over 90% in the last year, were people without immigration status, so people either seeking asylum or waiting for the Home Office to process their claim, or people who'd been refused and were in the process of trying to challenge that refusal. So I'm particularly going to talk about some of the impacts of the Act and the sort of wider package of things that's going on BRR service users who are in the asylum process. So the first sort of major area of impact that we've seen in the last couple of years relates to asylum and support. So asylum seekers who are destitute are entitled to financial support and accommodation whilst the decision is reached on their claim. Even before this Act, due to COVID, we've seen an increase in the number of asylum seekers accommodated in so-called temporary initial accommodation, which is full board hotel style, although hotel definitely doesn't describe what it's really like, which should be for a maximum of 28 days, whilst dispersal accommodation is found. And dispersal accommodation is usually a room in a shared property with kitchen facilities, and is where most asylum seekers, certainly until a couple of years ago, would live whilst their claim was determined. People wouldn't have any choice where that dispersal accommodation was or who they live with, but they had some autonomy through having their own space, which might in some circumstances be shared, but you know, at least being able to cook their own meals and receiving a weekly asylum support payment. But since the start of the pandemic and the ever increasing numbers in the asylum process because of delays in decision making, the Home Office has started to use hotels. They particularly started in COVID to use hotels that people weren't going and staying in on holiday to expand the number of spaces in initial accommodation. And the result is that we've seen significantly more people accommodated for lengthy periods of time in that type of accommodation, often a year or more. During the pandemic, obviously you will have seen that people were accommodated in barracks style accommodation. And in recent weeks, there's been much in the news about people being accommodated in Manston for kind of ever longer periods. The Act empowers the Home Secretary to house asylum seekers in different forms of accommodation depending on the stage their asylum claim has reached. It's hard to imagine that actually being achieved in the chaos that we see at the moment, where they're struggling to find enough beds for anyone in any type of accommodation. But what we anticipate is lengthy stays in inappropriate accommodation being the norm as we go forward, and the potential that people are moved around a lot more, moved into different types of accommodation, maybe or maybe not linked to what's going on with their asylum claim, maybe just linked to the chaos of the Home Office trying to make sure they've got enough beds for everybody. And that inevitably creates uncertainty for asylum seekers, prevents them settling in a specific area and benefiting from the advantages of being settled in a particular area, such as being able to volunteer, learn English or make friends. We regularly hear from service users that accommodation centres, initial accommodation hotels are very stressful places to live. Large numbers of people who are very stressed, anxious and traumatised being co-housed together. They're often physically isolated, so particularly post-pandemic, They're often far away from city centres. Some are very physically isolated in villages or in the countryside. Often the communal areas have been closed off. I think initially that was with a kind of COVID excuse, but that seems to have continued. And so that means often people have got kind of little chance to escape from their bedroom, which they might again be sharing with somebody that they don't know. Food is provided, but is often very culturally inappropriate and doesn't meet specific dietary needs. We've had some stories of people struggling to access facilities to wash their clothes and having to wait in their room, lying in their bed in their pants whilst their clothes are washed and dried. People not able to access toiletries or sanitary items or nappies and formula and things for babies. There's obviously been some public health concerns. You can see from some of the things on the slides here. The recent one in the news has been about the diphtheria outbreak, but there's been others, and there's also been stories of violence and abuse in these these initial accommodation centres. Next slide, please. So obviously Colin has kind of given you a bit of a flavour of what some of these things are that are in the Act, and I'm certainly not going to attempt to explain them all, but I think they represent a kind of catalogue of things that give asylum seekers a sense that they are unwanted, and that life is going to be very hard for them. There's a real sense of a kind of underpinning philosophy from the Act that people who come through irregular means should be penalised and are less worthy than people who come through recognised routes. Different systems will apply depending on people's arrival date, and there are, different processes will also apply to people depending on when they arrive and how they arrive. In very recent times, we've started to see a push by the Home Office to progress cases of people who've arrived since the end of June, when some of the aspects of the Act came into force. So that's seen some people in that situation who've arrived since the end of June having a very quick asylum interview within a matter of weeks, and so potentially moving towards a decision very rapidly, whilst others who arrived before that date are waiting months or years. As Colin said, often there's those disparities in how quickly decisions are made, and often we don't know why. This one, there does seem to be some reasoning behind it, but obviously that's creating a sense of injustice and unfairness. As Colin alluded to, people are finding it harder to find a legal aid solicitor, and that is, coupled with this sense of extra bits of the process that people have got to understand and get through, and increased penalties if people fail to do things in the right time. There is obviously, as Colin says, the chances of people being sent off to Rwanda in legal terms may never become a reality, but there is a lot of fear about that, and that could equally apply to lone women, to people who are LGBTQ+, and we have also had people who are children notified that they're in the early days when Rwanda seemed more of a possibility, that their claim was being treated as one which could potentially see them sent to Rwanda, because the Home Office had decided that they didn't believe them that they were a child. So the potential that in that case the person was later found to be a child, but obviously that could have led to a child inappropriately being sent to Rwanda. There's a lot that's unknown. I think you'll have got that sense from what Colin said, and a lot that will remain to be seen, kind of how things actually happen and go forward in reality, but that creates a lot of uncertainty and anxiety for people. Next slide, please. So I think one of the biggest things that we're seeing is the damage that is happening to people's mental health, the fear that it's creating, anxiety, confusion and tension. Many of the people that we see have already experienced multiple layers of trauma, firstly in their home country before they have fled, secondly, in some cases, repeatedly on their journey to the UK. For some, that journey has lasted many months, and they might have experienced exploitation, abuse, and almost certainly fear as they have literally fled for their lives. And then on arrival, they're faced with this incredibly dehumanising asylum system, which confuses them and, as Colin has said, increasingly criminalises them. We're hearing a lot of anxiety from people being worried about being sent to Rwanda, even though for lots of the people that we've heard that from, there is absolutely no chance that it would apply to them because of their arrival date or their means of arrival. But that just demonstrates the kind of level of confusion, and that, you know, these things that kind of get picked up on in the media can really create a lot of anxiety for people. People feeling that they are unwanted and less worthy because they haven't sought asylum through the preferred route. Also, these kind of different systems create division and jealousy between people, and so often we've found that asylum seekers are a really supportive community of one another, and you know, people from different cultures, from different countries, really kind of come together and support each other. But actually, this is really dividing people. This sense of, you know, you've got something different to me, and people not really understanding why that is. There's a real sense of a loss of hope, which is something so important to keep people going through the process, and in some cases a real kind of a sense that there might be a reduced desire to integrate, because a kind of sense of like, what's the point? Maybe they'll send me back at some point, although in reality, as Colin said, for most people that won't happen. It's quite hard to explain that to people. I think people are less emotionally ready to deal with the asylum process because of the poor accommodation they're in, the lack of support and the confusion. We've also heard about some people going underground and leaving their provided accommodation for fear of what will happen, which, you know, inevitably will lead to greater destitution, homelessness and exploitation. Next slide, please. So finally, I wanted to just mention a couple of specific groups that we work with, and Colin has already mentioned some things about the age assessment part of the Act. Age assessment is becoming an ever increasing issue. It's not a precise science. You know, there are 3 people here on this slide. Only one of them is an adult. Could everybody in this room really think that they could identify the right one just by looking at them? And in reality, that's what the Home Office is doing quite a lot. So in the last year, the Home Office disputed the age of twice as many children as they had in the year before. Since May of this year, we have supported 54 children who've been told that they are adults, often based on the Home Office looking at them, sometimes on a video screen, just like you're looking at these pictures now. That compares to sort of maybe 10 of those cases in a year pre-COVID. So it's a massive increase. Age really matters because children have different rights to adults and they get a different level of support. As Colin said, the Act makes provision for significant changes in how age assessment is carried out, and the creation of this National Age Assessment Board. I think that has the potential to leave children in limbo for longer as people kind of fight out who's responsible and who's right about age. Stricter approaches to age assessment obviously places children at risk of destitution and greater risk of exploitation. Quite a lot of the young people that we are seeing, those 54, are people who've left their accommodation provided by the Home Office, which is usually for adults, because they don't feel safe there, and have left there and gone elsewhere to find safety. But inevitably, that places them also in quite a risky situation. Finally, I just wanted to mention victims of trafficking. So there's also some provisions in the Act about victims of trafficking and raising the threshold at which somebody will be accepted as a victim of trafficking. Again, with the potential that you know, less people will be recognised, less victims will be recognised as victims of trafficking and receive the protection that they should. Out of interest, which is the adult? Which do you think? It's the one on. It's the one with holding the medal.
Okay, I was going to say this is a very macabre competition, but also very informative. I wouldn't have necessarily said that. Yeah, okay. Is that it? Have you finished then?
I have, yeah.
Okay, right. Thanks very much. I hope that people can see that we've firstly given an overall framework to how we see the Borders Nationality Act. Now we've looked at asylum seekers particularly, and now we're going to move on to Emma Gaspar, who is working particularly with refugees through the asylum route, to look a little bit at how we might feel that the Act will impact upon their lives. So over to you, Emma.
Hello, everybody. Thank you very much for coming today, and thank you to my co-speakers. They've both been really informative presentations. I'm going to try not to repeat too much of what's been said already, but there might be a little bit of overlap. So at ACH, we do work with refugees mostly. So the aim of this presentation is going to be to look mostly at the changes to refugee status that are going to be introduced and have been introduced by the Nationality and Borders Act. We will touch on some of the changes that have happened in the asylum system that have been mentioned already, mostly in regards to the impact this is going to have on delays and the amount of time it takes for people to get their decisions and the impact that this has on people's long-term integration. So if we could just follow on to the next slide. Okay, so yeah, as I said, at ACH, we do work with refugees who've very recently been granted their status, and we provide accommodation, training and general integration support for people. It can be quite a difficult time, but also a very nice time when people first get their refugee status, but it follows on from a long time in legal limbo in the asylum system. And all of a sudden, people have to make big decisions about where they're going to live and what they're going to do after having been forced into a kind of, a legal limbo where they can't make any progress. So we're here at that point to then help people move on and make decisions and plan what they want to do in the next stage of their lives. The Nationality and Borders Act is going to change refugee status, I think, in quite a big way for a lot of people. And it has been mentioned already. So I will look at what we're talking about is this Group 1 and Group 2 refugees. So the Nationality and Borders Act introduces this idea of differentiating refugees based on their mode of arrival. And as you can see here, this slide is actually brought out of the Act itself. So the main things that we're looking at here is Group 1 refugees, who are they? And Group 2 refugees, who are they? So Group 1 refugees are going to be people that have come to the UK directly from the country or territory where life or freedom is threatened, and that they have presented themselves without delay to the authorities. Everybody else will fall into Group 2. Next slide, please. So who is everybody else? As was mentioned by Colin, actually, there is not a way for most people to apply for protection in the UK without getting here. There's not an asylum visa. Many newspapers talk like there is. There is not one. Obviously, there are some resettlement schemes, and they are mostly based on nationality. So obviously, there's the Afghan resettlement scheme, we have the Syrian resettlement scheme, and the Ukrainian schemes, visa schemes, and the BNO schemes. But for most people, and globally speaking, there's not a way of applying for asylum from outside the UK, which means you do have to get here, which means it's a kind of geographical inevitability that you're going to pass through some, say, third countries in most cases, especially given that most refugee-producing countries are visa countries, meaning that people need visas to get here, which are also hard to access for multiple reasons. So the Nationality and Borders Act will implement back one, please. The Nationality and Borders Act will implement a two-tier asylum system for those that are granted protection. Group 1 refugees will continue to enjoy the same rights as refugees have done pre-June 2022. And what I mean there is the kind of 5-year routes to settlement, recourse to public funds and normal family reunion rights. For everybody else that falls into Group 2, they're going to be granted temporary refugee permission to stay. And we're going to look at that temporary in more detail in a minute. So the vast majority of people that arrived since the 28th of June 2022 will probably fall into Group 2. Certainly everybody that's arrived via the Channel crossings And the other way is anyone that's passed through any European country is going to fall into group 2, most likely. Thank you. Next slide. Okay, so we're going to look here at the actual conditions that are going to be applied to the 2 different groups. Group 1 is very similar to kind of the typical refugee status that we've been used to for the last 10 years, 15 years. So that's the initial period of 5 years permission to stay. Most people in the old system are given 5 years refugee status. And this then leads to a kind of route to settlement, which is a specific refugee settlement after 5 years. People have recourse to public funds once they've been granted refugee status, and full access to normal family reunion routes, which are a bit easier than typical family migration routes for non-refugees. So group 2, this is where we start to see the differences. And I would say actually the largest difference is going to be around the temporary aspect of the status and the length of stay. So an initial period of 30 months permission to stay, that's 2.5 years. And this will then be, people will need to then extend that leave over and over again. Family reunion will be possible, but there's going to be kind of extra legal tests. So people have to prove that family life is, that there are insurmountable obstacles to continuing family life elsewhere. We're going to look at that in a minute as well. In terms of settlement, so there's no longer going to be a direct route to settlement included for temporary refugee permission. People will have the right to apply for settlement under the 10-year long residency rules. So this is very different to what people have been used to in the old system. It means that people are going to need to renew various times before they have the right to settlement. And there's also other differences. So next slide, please. Okay, this is actually worth a nod as well. So humanitarian protection, which is another form of protection status, though not quite as high as refugee status, is now being downgraded in all cases, from my understanding. So I think this is regardless of route or mode of arrival. And what's basically happening is humanitarian protection, which with humanitarian protection, the government acknowledges that you are at risk of serious harm. You might not meet the normal refugee standards based on, like, particular groups or reasons for persecution, but there is acknowledgement that you are in danger should you return home. But now for anyone with humanitarian protection, regardless of mode of entry, the grant is going to be to 30 months, same as temporary refugee status. So that's 2.5 years, which will then be renewable. And again, settlement will only be available through the 10-year long residency route. So the normal 5-year settlement route is gone, unfortunately, for these people. Next slide, please. Okay, so temporary permission to stay. What do we mean by this? So I think the most striking difference between the old system and the new system is going to be this temporary nature of the new type of refugee permission to stay. People are going to have to apply to extend their leave every 2.5 years. It's going to be multiple times for most people before they have any chance to settle in the UK under the long residency routes. Application for refugee settlement was free of charge on the old route. So the kind of SETP form that people would use was free. Actually, long residency applications do have high fees. I think they're currently at £2,389 each. So actually access to funds is going to be a difficulty, not to mention solicitors' fees. If anyone has any better figures on the cost, do let me know. Next slide, please. Just a nod as well. So safe return reviews. This is a policy that does exist already, actually. So the Home Office safe return review policy is used when refugees under the old system apply for settlement. And what the safe return review does is it gives the Home Office caseworkers a chance to look at the case in the cases in the country, what are the conditions, and they just get a chance to look at whether the person still requires protection in the UK. If something has changed or there's been some behavioural issue that has changed the situation, then there would be the possibility to send that person, revoke the refugee status. It's worth saying that most of this it's very rare that the refugee status is revoked following the safe return review and that people are removed. Colin's mentioned that previously. However, this safe return review will be applied whenever people need to extend their stay. So for people with a temporary refugee permission, every 2.5 years, when they submit their application to extend their leave, the Home Office will apply the safe return review. And although it might be the case that very few people have their refugee status revoked or are removed, I think just knowing that you're going to have to reprove your case every 2.5 years and the possibility that your status can be taken away is going to really undermine people's sense of security. And I feel like it will make a difference to maybe long-term planning. So next slide, please. And following on that kind of train of thought, so what are the consequences for integration? I think there's certainly going to be people going to have to deal with increased uncertainty about their futures. Previously, you would be given 5 years, and if all things continued as normal, you'd have a route to settlement after 5 years, which means you could then start planning really for your life in a more long-term fashion. I think this new system is going to keep people in a kind of prolonged legal limbo before people feel that their status in the UK is really secure. Because you're looking at up to 10 years, right, until you can stay. And this is going to make a big impact on people, I think. You're looking at a minimum of 11 years for people before they're going to be able to apply for British citizenship. And obviously British citizenship brings with it rights and responsibilities, the right to vote, protections if people are abroad, and generally just the emotional feeling of being part of the community with no restrictions. So these delays, I think, are going to create further barriers to people's integration. It could be the psychological impact of having to undergo the stress of reapplying every 2.5 years. It could be actual logistical issues in terms of whether people manage to make those applications or not. And also in terms of planning, I mean, are you going to try and establish a business if you don't know if you're going to be here in 2.5 years? Are you going to start a university course? Obviously not all refugees do, but some do. And I feel like this increased legal uncertainty is going to really undermine people's chances to establish themselves in the UK. Thank you. Next slide. Okay, a few further considerations, and some of these are logistical and practical. I would say that in the case where you have more immigration applications, you have more immigration application deadlines, and you have more chances to miss those deadlines. So if people have to renew their status every 2.5 years, that means they need to be able to access legal representation. They need to make preparations for making these applications. And basically, there's just more chances for people to miss their deadlines and fall through the kind of legal gaps. What happens if you miss your deadline is normally that you will lose your legal rights to be in the UK and the conditions attached to that. So loss of right to work, recourse to public funds, and all the rest of it. And obviously the risk of removal as well. But even though saying that, even if you manage to make your application in time every 2.5 years, you still have to then deal with the kind of long wait times for immigration decisions. So it's quite typical that a decision can take up to 6 months, I think, for normal extensions of leave. And there's really serious practical and logistical issues that can come up for people whilst they're waiting. And it's worth noting that it can be difficult for people to prove their right to be in the UK when they're waiting for an immigration decision, especially with the hostile environment. I think a lot of employers and landlords are kind of a bit afraid to maybe take people on, even if they do have their legal rights, because they've made an application, because it might be hard to prove that. By the time we see this in the new system, I'm sure we'll be dealing with share codes instead of BRPs. There's already been problems with share codes we've seen practically, and people struggle to prove that they have the right to work, the right to access benefits, the right to rent. So I think this is going to be a bit of an issue. And I think it's worth noting as well, and it has been mentioned quite a lot, that there is a big problem with backlogs for the Home Office, and especially in terms of the asylum system. There's a lot of cases pending, decisions are really slow. And I think if you think about it now, every person is going to have to kind of reclaim every 2.5 years, extend their stay. The caseworker will need to do a safe returns review. I wonder, does the Home Office even have capacity for this? Because they've created a lot of extra work for themselves, if you think about it. And I don't know if that's going to add to increased delays again, and people, you know, waiting for really a long time, even to be able to extend their stay. But time will tell. Next slide, please. Family reunion changes. So I did mention this slightly earlier. People will still have access to family reunion. It's just they're going to have to make a few more steps and pass a few more kind of legal tests in order to get it. So people in group 2, which is people with a temporary permission to stay, they're going to need to be able to prove that there's insurmountable obstacles to family life continuing elsewhere, that is like outside the UK, and that refusal would breach Article 8 rights. So for the majority of people, this probably isn't going to be that much of a problem, if their spouses or their children are in their country of origin or the country of persecution. However, for people who might have their direct family in a safe third country or a third country generally, this could be an issue, because the Home Office will now apply this test to say, okay, is it possible for you to go and meet your family elsewhere and live there? Do you have the right to leave in that country? Could you access protection in that country? So it might be that for most people, it doesn't make that much of a difference. It might be that with legal representation, people can kind of overcome this legal test. But I think it just kind of adds an extra step for people to be able to get their families to reunite with them. And it will probably be an issue for some people whose family are in third countries. Thank you. Next slide. Okay, this is, Colin did talk about this actually at length, so I won't go into it too deeply, but the kind of inadmissibility and safe country removals. Now, this is actually going back and looking at the asylum system itself. Inadmissibility criteria has existed already in the immigration rules before the Nationality and Borders Act. I think the main difference here is that now anyone that's passed through a safe third country and has been present in that safe third country can be viewed as inadmissible. Their claim can be viewed as inadmissible, which means the Home Office don't have to look at it. But the big difference is actually that that person can then be removed, not to that country that they've come through, but to any other safe third country. So this is kind of the Rwanda scheme in legislation, if you will. Although, as Colin mentioned, the Rwanda memorandum actually predates the Nationality and Borders Act, which is quite interesting. Again, like, we don't know how many people will actually face removal. There are ongoing legal battles and no one has been removed as yet to Rwanda. So there is still the stress that people go through, as has been mentioned by Beth, I think, in her presentation, that people are worried about this. Fear is there. Mental health is going to deteriorate with this kind of thing hanging over people's heads. And the other thing is that it's going to cause more delays. So if the government does not manage to make an agreement with the safe third country, then they will have to look at the person's claim. In my head, I think it's 6 months they have from the date of claim to the date of removal. They have up to 6 months to remove that person. If that 6 months goes by and there's no country that will agree to take people, then the Home Office will have to assess the person's asylum claim under normal circumstances. However, that's just going to create more delays again. Next slide, please. So yeah, as I said, it's unclear how many people will be removed to safe third countries, and this really depends on if more deals are made, if the Rwanda agreement goes through. But yes, the increase of delays is going to be a serious problem. I think it's thought that up to 150,000 cases are pending in the asylum system currently, which is a huge backlog. And, you know, with this now adding extra layers in terms of inadmissibility, attempts to remove people, you're just looking at more time that people are spent in legal limbo. It's more time that people are forced to wait in the asylum system where they don't have the right to work. They're losing years of their lives with no chance to gain any work experience, really limited income, even restrictions on education and training. So it's just time that people are losing, and that's not what you want when you've just come to a new country and you're starting from zero. And I would say also, just anecdotally, because we work with people when they've received their status, you can see the difference. You can see the difference in people's mental health, and how quickly they manage to integrate. The longer people spend in the asylum system, the harder it is to establish themselves later. So anything that increases those wait times, for me, I think is really negative for people's integration. Next slide, please. So, okay, we've come to the end. What can we do to prepare? So I know for ourselves at ACH, we won't be seeing anybody under this new system for some time. The reason for this is obviously it only applies to people who have claimed asylum since the 28th of June 2022. And as said repeatedly, people are waiting for years potentially for asylum claims to be decided. So it's going to be a long time, I think, until we see people under this new system, and it will be even longer, obviously, until people are looking to extend their stay and to renew. I think for us, the best thing that we can do is to stay up to date with the changes in policy and guidance around the Nationality and Borders Act. And obviously, I think for any organisation that is in a position to give information, advice and guidance to their service users, we need to try and expand our capacity and our understanding about the Nationality and Borders Act, so we are ready basically when people start coming through our doors. Thank you very much.
Okay, thank you very much, Emma, for that. I think we've had three really succinct and informative presentations, which I think fitted very well together in terms of providing an overall framework from a legal point of view, looking at asylum route and the consequences of the Act for them, and then downstream, if that's the right word, in terms of the implications for refugee integration and resettlement. So over to you, Rosie.
Thank you, David, and thank you to Colin, Beth and Emma for such fascinating discussions. I think their presentations really showed that for organisations working with refugee and migrant communities, campaigning against the Nationality and Borders Act still remains crucial. And as we've seen, the Act propels this divisive rhetoric that has real effects for people, and negative effects on people seeking asylum, and also for longer term effects on integration that will have a huge impact for the future. I think it's also important to note that the Act will affect people within the wider context of chaos in the asylum system, and our next step should take this into consideration and maybe work within this wider context of kind of delays and lack of Home Office kind of organisation. I think from the discussions we've had here today, I'm going to suggest kind of three different ways we can take forward steps after today's discussions. I think the first one is around the kind of concept of demystification, and working to demystify some of the laws and policies that affect asylum seekers and refugee communities, and the impact they're likely to make. I think there's a major need to simplify and translate some of the policy and legislative changes to different audiences, especially as so many of the impacts remain uncertain. I think there's a lot of kind of translating and comms work to do around that subject. I think for one group, for frontline staff, I think from what Emma said, it's really important that we create resources and guides for frontline staff to kind of demystify the likely effects of the Nationality and Borders Act and kind of preempt some of the effects for their clients. I think this could be done through kind of more peer training and workshops, kind of conversations like we've had today about kind of practical ways and methods of supporting people through these kind of system changes. I think there's also a need for kind of demystification for people going through the asylum system to know their rights and what effect this act might have on them or not affect them, to what extent. I think if people are aware of their rights and can advocate for themselves and for change, they have more power to kind of build lives in the UK and navigate the system. And this includes practical advice on kind of where to seek guidance and support, and where to seek legal advice. As Beth said, I think we need to do this to make sure that no one falls through the gaps and kind of has to go underground because of some of these changes. I think there's also work to do around demystification for employers and for the education sector, who we find, especially through our work at ACH, they're not always aware of kind of the rules and regulations around people with refugee status having the right to work, the right to education, and can be put off kind of hiring or educating due to these perceived barriers. I think another of the ways we can take next step forwards is obviously through kind of campaigning work and advocacy work. I think campaigning against the Act in the wider context of the hostile environment policies and kind of inappropriate kind of services is a good way forward. I think, as we've seen, this Act is coming as part of a wider context of Home Office issues and the hostile environment. I think one of the things we need to counteract through campaigning is kind of divisive language and policies. And as Colin demonstrated, although it's an act of political theatre, perhaps, this does create real effects, especially in terms of the way that we see people coming to the country, in terms of the differential treatment of refugees, further kind of supporting the production of ideas around illegality and of a good and a bad migrant and refugee, which we've seen doesn't have any basis under international law, but is something that these policies are propelling. So I think campaigning against this divisive rhetoric remains crucial. I think another good way of angle for campaigning is pointing out elements of this legislation that just doesn't make any sense, as we've seen throughout this discussion. I think things like what actually is a safe and legal route to claiming asylum for people who don't fit into resettlement criteria, the ineffective and costly nature of the Rwanda scheme, or the ban on asylum seekers working, if you're going to take the wider context of asylum policies. Lots of these policies just don't make sense practically for anyone, for the country, or for people that we're supporting as refugee organisations and asylum support organisations. They're about kind of placating a certain anti-immigration group of voters that the government is targeting. So I think one of the next steps is working on kind of campaigns and advocacies that illustrate that these policies don't work for anyone involved. Lastly, I think one of the things to take forward is working more at a local level, and especially with local authorities. I think it's important for organisations working with people seeking sanctuary that they work with local authorities to push back against the Act and work at a local level. I think this is especially the case around things like housing, mental health provision, and kind of working with education and employment. Local organisations working at the city or regional level, working with local authorities, can kind of take some practical action to make changes for the communities we support. And I think this is where locally embedded organisations can make a real difference. I also think that building up networks within a region to help make sure that these services are kind of joined up. And in Bristol, we've got things like the Bristol Refugee and Asylum Seeker Partnership for us, which is working together at the local level to make sure services are talking to each other and coordinating on the situation for the people we support. Yeah, and I think just finally, if I had one final thing to take away, I think it would just be keeping up conversations like the ones we've had today, to keep having these conversations and kind of updates on the wider kind of political, legal and practical situation for people seeking sanctuary.
Okay, thank you, Rosie, for that. And we have 2 minutes left, which is fine. So I want to thank all the speakers, Colin, Beth and Emma. Beth is in her last few days as the CEO of Bristol Refugee Rights, but she's only left, she's reminded me, moving next door to Wellspring. So I'm sure we're going to see her again with a different hat on. So thank you to all of those. Thank you to Rosie for doing that wrap up. And thank you to Senna, our colleague who's been doing the technology behind the scenes, without which this wouldn't have been possible. And for Rosie for the organisational work that made it happen too. Because we could all speak, but actually making the technology work is another thing. So thank you for all of that. We would be very happy to keep in touch with people. I put mine and Rosie's email addresses in the chat. Somebody's mentioned LinkedIn, which would be useful. Whether I've got time to do that before we go offline and I lose that connection, I don't know, but I will try. So do keep in touch with us if you want to. Email us or get in touch with us through some other route if you wish. And we can add you to our mailing list for future events. And I think we will commit at least to do some of the follow-up things that Rosie's mentioned. I think particularly we could produce a short demystification guide to this process, which would be aimed at what I think this approach is what I call third-party frontline workers. So not our staff so much, but those people who work with employers, who work with provide healthcare, provide education, provide training, and provide general community support, who are not necessarily experts on the refugee and migrant system. I think it's very important that those people are as fully informed as possible about the situation that we're in. So I don't know if anybody wants to say anything really vital now. We'll leave the chat open can we leave the chat open for a couple more minutes, Rosie? Is that possible? But let's call it to an end. It's 2:30. That's the time that we did say we'd finish. So thank you to the speakers. Thank you for taking part. I hope it was useful, and let's make sure it's part of an ongoing process, not just a final act. So thanks very much. Bye.